But our top story tonight is a new lawsuit against Indiana's new abortion law. Both Planned Parenthood and the ACLU are calling the new restrictions unconstitutional.
Rich Van Wyk on the reasons why opponents say the new law puts women and their doctors at risk.
Planned Parenthood and ACLU of Indiana are asking a federal court judge to declare Indiana's new abortion law unconstitutional and make their legal arguments sound almost simple.
This statute does something that the United States Supreme Court has said repeatedly cannot be done.
The statute prohibits women from having abortions based on the fetus's race, color, national origin, ancestry, sex, or diagnosis of a disability. Doctors must counsel their patients privately. If an abortion is performed for any of those reasons, they could lose their licenses.
You cannot prohibit a woman's right to obtain an abortion. You cannot invade a woman's right to privacy.
Planned Parenthood and women's rights groups fought unsuccessfully to keep lawmakers from passing the legislation and Governor Mike Pence from signing it.
We have a governor who finds his own personal views on these things and his own personal ideology more important than good public health policy and constitutional behavior.
Hearing of the lawsuit, Governor Pence defended his decision.
I respect the feelings of every Hoosier on this issue, but I'm pro-life, and I stand by my decision to sign this legislation.
The lawsuit is no surprise. Supporters of the legislation expected it. The law goes into effect July 1st, but the ACLU intends to ask the federal judge to issue a preliminary injunction, delaying the implementation until there's a ruling in the case.
And no one knows when that will be. Supporters of the abortion legislation insist the legal dispute isn't nearly as clear-cut and simple as opponents make it out to be. They claim there's an issue of discrimination to consider. We're going to look at that at 6.